Good afternoon.
Good afternoon.
I'm going to get all my documents up before we go ahead and get on the record. Ms. Williams, in the meantime, you can go ahead and live stream. All right, I want to go ahead and get started in this matter, cause number 2015614. This is the case styled Miller versus Dunn et al. And before we get started, I do want to address an administrative or issue, and that is that in the proceedings that we've had prior to today, that we've had via Zoom, we've had a lot of difficulty really with the court, for the court reporter, with people jumping in and out of the Zoom proceeding, making it difficult for her as she's trying to get the record. As you all know, the court live streams the proceeding consistent with the Texas Supreme Court order so that the public can have access to the proceeding. And so that is the manner in which folks who are not parties and not counsel to the proceeding will need to access the proceeding, so that I reduce the likelihood that my court reporter is going to be having problems getting the record, because there's so many people popping in and out. The last hearing in particular, we had a lot of people who were dropping off and then they drop back in. And for my part, as the co-host of the session, of course, the court reporter's hands are engaged, so she can't keep admitting people who drop off. And of course, I'm trying to pay attention. So it's disruptive to me to have to keep looking in the waiting room and seeing if somebody needs to be admitted and trying to keep up with that. And all of that, of course, is addressed with the live stream. That's why we have it, so the public can have access to the proceedings. So I wanted to address that, Mr. Miller, because I know that you mentioned to me before that some of these folks are supporters, and I certainly don't have any issue with anybody watching the proceeding. I just want to make sure that we don't impair the reporter's ability to get the record. So folks that were in when we got started, we admitted, we let everybody in, but as we go forward, anyone who wants to get on and observe will need to do that via YouTube, the court's YouTube channel. Okay, so with that, let me go ahead and get your appearances.
Yes, Your Honor. Bradley Miller, pro se, plaintiff.
Your Honor, I may be the next in line. At.Elayna Erick, representing the estate of Marianne Michalopoulos, aka Marianne Brousseau.
Your Honor, I'm Scott Graydon. I'm here on behalf of Judge Andrea Plumley.
Your Honor, this is Earl Nesbitt. I'm here on behalf of Associate Judge Daniel Diaz and Dallas County, Texas.
Your Honor, this is Sarah Klein, attorney at McDonald Sanders. We represent the Hockaday School. These defendants have previously been dismissed, so I'm just observing today.
Thank you. And I don't recognize any of the other names here. Let me just make sure I've got everybody. Okay, well, I think we are ready to get started. Of course, this is the Rule 91A motion, Ms. Erick, that you filed on behalf of your client, and the court has had the opportunity to review the record in connection with this matter. And you may proceed with your arguments.
Thank you, Your Honor.
I'm sorry, Ms. Erick, one other thing. I just want to remind everyone that this proceeding is being conducted, although virtually, via the Zoom platform, as though we are in the 116th District Court in person, and that is that all rules still apply, including the rule that this proceeding not be recorded by any means by anyone who's participating in the proceeding as a party or a lawyer or at all. The court does not give permission for this proceeding to be recorded. No permission has been requested, and none certainly has been given. Do we have the agreement of everyone here to go forward under those circumstances?
Yes, understood, Your Honor.
Yes, Your Honor, I agree.
Your Honor.
Mr. Nesbitt, I believe I heard your affirmation.
Yes, ma'am. We agree.
Thank you. And Ms. Klein?
Yes, we agree, Your Honor.
And with that, Ms. Erick, I'll turn it over to you.
Thank you, Your Honor. Pursuant to Texas Rule Civil Procedure 91A, defendant may move to dismiss a cause of action on the grounds that it has no basis in law or fact. A cause of action has no basis in law if the allegations taken as true, together with inferences reasonably drawn from them, do not entitle the claimant to the relief sought. A cause of action has no basis in fact if no reasonable person could believe the facts pleaded. At this point, this court has heard the background facts and allegations against these defendants multiple times, many times over. So I will not go through a summary of all of them. Additionally, in the interest of time, and because this court knows and has heard the elements of each cause of action, which are also in our motion, I will not go through each of those, every elements for every claim unless the court wants me to do so. I will just focus the court on the one allegation made by plaintiff that forms the basis of all of his claims against defendant Michalopoulos and how his allegations do not entitle him to the relief sought. The personal instigation that plaintiff alleges is the basis for all of his causes of action against defendant is related to one email allegedly sent by her to defendants Tally Dunn and Patty Rochelle on November 10th, 2014, which was mysteriously intercepted by plaintiff and attached to his petition. In that email, defendant stated, "I am certain it will never cause you to lose business over it because it is totally unbelievable and of no interest. The only action I intend to take is to write him as board chair explaining that because this involves parents and children of the school, it is improper for me to address." In a follow-up email, she stated, "What if you move for a protective order based on this communication?" This was in November 2014. Months later, in February 2015, defendant Tally Dunn and her gallery filed a petition in the district court alleging misappropriation of trade secrets, tortious interference with business relations, harmful access by computer violation, Texas wiretapping violation, Texas Theft Liability Act violation, and requested an injunction against plaintiff's disclosure of confidential information and interference with her business. Not one of these claims was a motion for a protective order, which is a very specific type of order. In fact, not only are none of the claims that were filed by Tally Dunn for a protective order, but one of them, tortious interference with business relations, is one that defendant Michalopoulos specifically told Tally she didn't have. It would be impossible for a reasonable person to connect these emails outlining the only action defendant stated she would be taking and a what if comment regarding a different cause of action to the alternate course of action affirmatively taken by Tally Dunn and her counsel in a civil courtroom months later. It would also be impossible to conclude that these emails instigated an entirely different family law modification proceeding filed 6 months later, immediately after an incident between Mr. Miller and Mrs. Dunn at the Dallas Art Fair, which has also been repeatedly described in this proceeding. It's also impossible to connect her emails to an order signed by the family court a year later in that modification proceeding that was filed by Ms. Dunn. Furthermore, Mr. Miller's allegations regarding these two emails, even if taken as true, do not entitle plaintiff to the relief sought for any of the causes of action asserted against defendant Michalopoulos. For counts 1 through 5 in the petition, which were allegations of violations of the United States Constitution. In the petition, plaintiff asserts that defendant, a private individual, violated his constitutional rights under the 1st, 4th, 8th, and 14th Amendments pursuant to 42 USC 1983. None of these claims have any basis in law or fact. It is fundamental that the Constitution applies only to government action and not to the conduct of private individuals. And see Black versus Johnson, 82 Southwest 3rd, 44. Specifically, the courts have either ruled that each of the amendments can only be enforced against the federal and state governments and not private individuals, or the amendment itself only applies to government action. Plaintiff argues that because defendant Judge Andrea Plumley and Judge Danielle Diaz, as state actors, allegedly violated plaintiff's constitutional rights. And to the extent that defendant conspired in those violations, defendant Michalopoulos is liable for his Section 1983 claims. The case law cited by plaintiff in this regard, Addicts versus S.H. Kress and Co. and United States versus Price, address situations in which private persons jointly engaged with state officials are acting under color of law for purposes of these 1983 actions. There is no such fact pattern here. The allegation made by plaintiff is that the order signed by Judge Plumlee on November 17, 2016, resulted from a lawsuit personally instigated by Michalopoulos in the email we previously addressed. And so based on that email to a different person, he alleges she's acting in a conspiracy with state actors. However, plaintiff has failed to connect how defendant Michalopoulos was acting jointly with the state actors and under the color of law in order to get Judge Plumlee to sign the order she ultimately signed a year after her email. Plaintiff further argues that the U.S. Supreme Court has ruled that claims under 42 U.S.C. 1985 do not require the participation of a state actor and thus can be brought against a private individual. While this is irrelevant because plaintiff's petition does not contain any claims against any of the defendants under 42 U.S.C. 1985, and this motion is based on the pleadings on file, 42 U.S.C. 1985 and its case law involve private conspiracies between state actors and private individuals. Again, plaintiff has failed to show any facts that would lead a reasonable person to believe there existed such a conspiracy, which is a mutual agreement or understanding between defendant Michalopoulos and Judge Plumlee and Judge Diaz to violate plaintiff's constitutional rights. Accordingly, claims 1 through 5 of the petition must be dismissed. Claim 6 in the petition involves fraud. Plaintiff fails to allege any facts supporting any of the elements of fraud against defendant Michalopoulos in this proceeding. In the petition, plaintiff does not allege that Mrs. Michalopoulos made any misrepresentations to him at all. In his response, he argues that because defendant instigated a modification suit filed against him by his ex-wife through the email she sent 6 months prior to its filing, and this modification suit, not filed by Mrs. Michalopoulos, but filed by Tally Dunn and her counsel, contained misrepresentations to the court. And because plaintiff was served with the modification suit, that defendant made misrepresentations to him through this lawsuit, through a lawsuit that she neither instigated, directed, drafted, filed, or served on Mr. Miller. No reasonable person would consider this to be a material and false misrepresentation made by defendant to plaintiff that he relied upon to his detriment. Further, plaintiff fails to properly allege that defendant committed fraud by non-disclosure. In the petition, plaintiff does not allege any facts that she failed to disclose to plaintiff at all, let alone any facts that could form the basis of this claim. But in his response, Mr. Miller alleges that plaintiff failed to disclose the extent of her involvement in his 2013 divorce case and in his 2015 modification case, and that failure caused him harm. First, plaintiff fails to allege facts that support his claim that defendant was involved in his 2013 divorce case or his 2015 modification case at all, let alone a duty that she had to speak or that she intended to induce plaintiff to take some action or refrain from acting, or that he relied on her non-disclosure to him, to his harm. Plaintiff has not alleged any of these facts because they simply do not exist. Plaintiff also alleges that a misrepresentation to a third party that injures the plaintiff meets the standard for fraud. And so it doesn't matter that defendant Michalopoulos made no misrepresentation to him directly. However, again, plaintiff has not alleged a misrepresentation to the court that she made because she did not file a petition against him. Accordingly, because there are no facts alleged that would form the basis for a claim for fraud against defendant, count 6 against defendant Michalopoulos must also be dismissed. Count 7 in the petition is conspiracy against rights and conspiracy to defraud. Plaintiff alleges that defendant Michalopoulos personally instructed Dunn and her attorneys to request an illegal gag order to prevent him from speaking to Hockaday or to anyone about the actions of Dunn and Michalopoulos. And because this act eventually resulted in an order issued against plaintiff, 18 U.S.C. 1341 was violated. Although not specifically pled in his petition, in his response, plaintiff alleges that the conspiracy to defraud is that defendant personally instigated Dunn's groundless 2015 custody modification suit that resulted in the violation of at least his First Amendment right to free speech and 14th Amendment right to parent his child. Plaintiff alleges that defendant and defendants Dunn, Finley, Rochelle, Plumlee, Diaz, and Hockaday all conspired together to defraud him, and that specifically, defendant knew that filing a groundless suit violated state law. As we've already addressed, defendant did not file a lawsuit against plaintiff, nor did she instruct or direct anyone to file the lawsuits Tally Dunn ultimately filed against plaintiff the following year. And plaintiff certainly has not alleged facts that a reasonable person could believe that such a conspiracy to violate his rights exists. Plaintiff argues that defendants Michalopoulos, Dunn, and Hockaday conspired together and that it was worth $100 million in fundraising money to sacrifice his peace and constitutionally guaranteed freedoms, as well as his daughter's psychological health. Somehow linking the fundraising efforts of defendant and her prior position as board chair of Hockaday to a conspiracy against him. During her life, Marianne Michalopoulos served on the boards or raised funds for many organizations in this Dallas community. This includes not only Hockaday, but also UT Southwestern, Planned Parenthood, Girls Inc., Austin Street Shelter, Genesis, Cristo Rey, and she even served on the board and raised money for Mr. Miller's own alma mater, St. Mark's. To connect her hard work and dedication and efforts that benefited all of these organizations with any lawsuit filed by any parties connected to these organizations is overreaching, and it demeans the impact she made on these communities. To assert that Mrs. Michalopoulos instigated lawsuits against plaintiff in order to raise or protect her ability to raise $100 million for Hockaday is baseless, inflammatory, and beyond the pale. For all these reasons, count 7 against defendant must be dismissed.
Ms. Erick, before you go on, I have a quick question as it relates to the fraud claim, and that's also ties to the conspiracy because, of course, one of your arguments is that because there's no fraud claim that is based in law or fact, the conspiracy to commit fraud fails as well. One of the arguments made on the fraud claim is that the statute of limitations bars it. I didn't hear you touch on that. I'm not sure if you're planning to touch on statute of limitations at the end relative to all of the claims, or if you were standing down on that argument. If you're waiting for the end, I'm happy for you to do that. I just wanted to check in as I'm going through my notes and trying to keep track.
Yes, Your Honor, I was going to address that at the end because, that's a calculation argument, and I was just going to handle all that at once, if that's okay by you.
Thank you.
All right, count 8 of the petition involves Mr. Miller's negligence claim. Plaintiff has not alleged facts or case law that prove that there exists a legal duty of defendant as the board chair of the school his daughter attends to protect plaintiff against injury. Because plaintiff has not and cannot allege the facts required to support the first threshold element of a claim for negligence, that of duty, this claim against defendant should be dismissed. Furthermore, plaintiff argues that defendant breached her legal duty owed to him and his daughter by instructing defendant Dunn to file her groundless custody modification suit. As we have gone over multiple times, there is no connection between her emails regarding a protective order and the modification suit filed 6 months later following an intervening incident. and there was certainly no instruction. Accordingly, count 8 must be dismissed against defendant Michalopoulos. Count 9 is intentional infliction of emotional distress. The entire basis for plaintiff's claim here is that defendant intentionally instructed Dunn to file groundless lawsuits with the express intent to violate his rights, as evidenced solely by the email sent to Dunn and her counsel. For the reasons already addressed, this email did not instigate lawsuits filed by Dunn the following year, and it certainly did not cause plaintiff to have his daughter taken away from him. As one, she was not taken away from him. His parental rights have not been terminated to my knowledge, and he has a possession schedule he can exercise. And 2, defendant had nothing to do with the order signed by the family court after hearing the facts presented on the modification suit. Plaintiff has failed to allege any facts taken as true that would allow a reasonable person to believe that she did. Count 10, malicious prosecution. Not only is plaintiff unable to prove that any proceeding against him was instituted at the insistence of defendant and that she did so with malice, or that there was no probable cause for any action filed by the other defendants against him, but there have been no proceedings that were terminated in Mr. Miller's favor, only in the other defendant's favor, and that is a required element of this claim. Accordingly, there's no basis in law or fact for count 10 against defendant, and so this claim should also be dismissed. As to the arguments about statute of limitations, as Your Honor noted, there are statute of limitations that address all of these claims. The statute of limitations for fraud is 4 years. The statute of limitations for conspiracy to defraud is 2 years. The statute of limitations for negligence is 4 years. And Mr. Miller argues that because he filed an identical lawsuit, identical claims in the federal court proceeding, that it told his statute of limitations. The issue with that, however, is that Mr. Miller never served any of these defendants with those lawsuits that he filed in federal court. And so how could it toll the statute of limitations when that federal proceeding never effectively proceeded and it was dismissed before anyone was served? Additionally, Mr. Miller is using the federal court proceeding as a way to play 2 hands at one time. He filed this federal court proceeding. It was dismissed before he served anyone. He never effected service. Then he filed this proceeding, and if you remember, he tried to stay it in order to wait to hear what happened in his federal court proceeding. To allow Mr. Miller to play one court against the other in order to either see which court gives him a better ruling or toll the statute of limitations in his favor is patently unfair. Finally, as to attorney's fees, under Texas Rule of Civil Procedure 91A, the court may award the prevailing party on the motion all costs and reasonable necessary attorney's fees incurred with respect to the challenge cause of action in the trial court. Because this court has not assessed attorney's fees against plaintiff in any of the prior proceedings, I will not spend the court's time arguing this point again unless the court wants to hear evidence on it, except to say this. Not only is the plaintiff abusing the court system to try to punish these defendants, but his utter disregard for basic decency and respect throughout the pleadings filed in this proceedings is unconscionable. The maligning of the character of every defendant who are serving their communities in one way or another brought into this action is unnecessary, disrespectful, and inflammatory for no purpose other than to punish. If Mr. Miller believes that his child was taken away from him, he has another remedy. The family court has jurisdiction over his daughter until she is 18 years old. And if he has the basis, he can ask the court to modify his order. However, he spent the time since the divorce proceeding filing lawsuits in civil court instead. As evidenced by the appeals of this court's rulings that he's already filed, Mr. Miller may never stop using the court system in this way without an assessment of attorney's fees against him. Without court action, Mr. Miller may never stop fighting, not for his daughter, but to publicly harass those he believes wronged him since his divorce. We ask the court to grant the estate's Rule 91A motion and to dismiss all causes of action against the estate at this time.
Mr. Miller, you may respond.
Yes, Your Honor. Just a couple of preliminary things. Ms. Erick, on August 11th, yesterday, filed an objection to an affidavit I submitted as evidence for today's hearing. As she noted, it was the affidavit was previously filed in the Supreme Court of Texas in relation to a prior appeal. That's on page 2 of her objection, which is true. Of course, it was filed as tab A in the appendix of Texas Supreme Court case mandamus petition, case number 16-0487. And Ms. Erick also protests that a motion to dismiss based on Rule 91A is determined solely on the pleadings. That's also on page 2 of her objection. And Ms. Erick is implying that this affidavit has not been submitted in the pleadings in this case, but of course it has been. In the plaintiff's verified original petition in this case, on page 14, I cited Texas Supreme Court case number 16-0487, and I subsequently stated also on page 14 of that of my petition, quote, Plaintiff Miller hereby incorporates the prior filed documents in these cases the same as if all of the same facts and allegations had been fully set forth herein, unquote. So this 2016 affidavit has already been submitted to the court in pleadings in this case, and the court may certainly consider it today. I understand why Ms. Erick would not want this affidavit considered because, of course, it contains allegations that make her client look unseemly, I would say criminal. But if Ms. Erick wasn't diligent enough to read the documents cited in the pleadings in this case, that's not grounds for excluding the affidavit. I should add that most of what is in that affidavit is also contained in the original petition in this case, so it really makes no difference. With regard to exhibits generally, under the Texas Rules of Civil Procedure, Rule 91A6 specifically allows exhibits that are permitted under Rule 59, and Rule 59 states that any document constituting in whole or in part the claim sued on may be made a part of the pleadings. And of course, that affidavit submitted for the court's consideration today has been mentioned in the original petition, as I said again on page 14. Thus, this document certainly constitutes part of the claim sued upon, and it's allowable under Texas Rules of Civil Procedure, Rule 59 and 91A6. I hadn't planned to go into too much of the timeline of this case because, as Ms. Erick noted, we have been through it before, but Ms. Erick's argument contains so many false statements and misrepresentations. I feel the need to set the record straight, at least on much of the timeline. So if you'll indulge me, I'll go through it quickly before I get to my legal arguments. Just generally, the suit that I've filed alleges that agents of the Hockaday School, including defendant Miriam Malopoulos and my ex-wife, defendant Virginia Talley Dunn, who were both subsequent board chairs of the Hockaday School Board of Trustees. And also the Hockaday School generally violated the plaintiff's constitutional rights, committed fraud against the plaintiff, being myself, and conspired to commit fraud and to violate my constitutional rights. Specifically, as Ms. Erick mentioned, due to the actions of Hockaday and its agents, including Nicolopoulos and Dunn, I've been subject to various illegal gag orders since 2013, and I remain under one now. There's a permanent gag order has been in place since 2015, despite 4 appeals to the United States Supreme Court. And I have not seen my daughter since May 18, 2018. That's more than 3 years. Contrary to Ms. Erick's misstatement, there is no possession order in place that I can exercise. Well, technically there is, because as I've argued before, the temporary orders signed without jurisdiction and fraudulently by defendant Diaz on June 7, 2018 are void. So technically she may be right in that the prior possession schedule does remain legally in effect. The problem is that I have 2 judges in the 330th Family Court who believe otherwise and could have me arrested for trying to pick up my daughter for dinner on Thursday night, for example. And certainly I will never stop fighting for my daughter. She's absolutely right about that. And also she is incorrect about the fact that my my legal efforts have been abusive. They have only been defensive. And if Miss Erick has children or will have children someday, I hope she understands that as a lawyer, especially, that the parent-child relationship is sacrosanct and protected under the 14th Amendment of the United States Constitution. And it's something that should not be interfered with by the whims of an abusive party, being my ex-wife and Ms. Dunn and all the defendants in this case. Just to go quickly through the timeline, if I can, Defendant Dunn was the chair of the Hockaday Board of Trustees from 2011 to 2013, and Ms. Mikolopoulos immediately succeeded Dunn in that position as Hockaday Board Chair from 2013 to 2015. Ms. Dunn and Ms. Mikolopoulos both graduated from the Hockaday School. They didn't know each other prior to serving on the Hockaday Board together from around 2009 onward, and I know that because Ms. Dunn and I were together from 1985 through the time she filed her divorce in 2013, and Ms. Mikolopoulos was never in my home during that time, and I was well aware of their relationship on the board. As I've described before, in 2011 and 12, Ms. Dunn began behaving in an unusual and very erratic and frightening ways. She began drinking. She forced her best friend and business partner and the godmother of my daughter out of her art gallery business, in part by lying to me about her partner's conduct and claiming the partner was, quote, on drugs and was stealing from the gallery, none of which was substantiated. She also, Ms. Dunn, my ex-wife, began apparently, which I noticed later, had been sending romantic text messages to artist David Bates for months prior to my discovering that in 2012. I submitted these text messages into evidence in a hearing in the 330th Family Court in June and July of 2013, and Dunn did not object to that at the time. She, of course, is objecting to the presentation and submission of these text messages in the current civil suit. To move on, in 2012, Dunn, who was the Hockaday board chair at the time, became irrationally convinced that our daughter was never going to get into Hockaday if we didn't apply immediately. She threatened to kill me, called me threatening to kill herself during various conversations in 2012 about moving our daughter to Hockaday. I began recording some of these conversations to get psychiatric help for her and also for my own safety. Dunn also once told me in dead seriousness, "I'm going to kill you in your sleep." So this is sort of some background to what came later during our divorce. Dunn filed to—
Mr. Miller, I'm sorry, I don't want to get too far afield of what
Sure.
we're tasked with today. I really want to focus on what
Yeah.
is the basis of your
Yes.
claims against the defendant, the estate of
Absolutely.
Mikolopoulos. And to just get very pointed, I want to focus first on counts 1 through 5 and this idea that those counts can be maintained against her, even though they don't involve the government, as is contended.
Yes. I will get to my legal argument. If I could just cover the issue about the email that's central to this hearing that Miriam Mikolopoulos sent to Ms. Dunn and Ms. Rochelle, that would be all right?
To do that, yes.
Yes. So we went through a divorce. I was gagged for much of 2013 and until the divorce became final in April 2014. I was gagged through 2013 to 2014. I began to communicate once the gag orders expired about Dunn's conduct during our divorce, including with the Hockaday board, because our daughter, of course, was being moved from one school into Hockaday. And my ex-wife, Ms. Dunn, defendant Dunn, was the board chair at the time. And then Ms. Mikolopoulos became the board chair subsequently. So I began emailing Ms. Mikolopoulos as the Hockaday board chair and the primary executive officer, chief executive officer of Hockaday, about what was happening to me and to my daughter vis-a-vis Ms. Dunn. I sent an email to Ms. Mikolopoulos on November 9th, 2014, and that's, you can see that on the plaintiff's original petition at Exhibit B. And the very next day, in response to my email about Dunn's conduct, defendant Mikolopoulos forwarded my email to defendants Dunn and her attorney, defendant Patricia Rochelle, recommending that they, quote, move for a protective order. Now, Ms. Erick is stating that a protective order is not a gag order. It boggles the mind and defies credibility, any credibility, to state that there's no connection between this email that defendant Michalopoulos sent to defendants Dunn and Rochelle, instructing them to move for a protective order in a court case that wasn't even open at the time in family court. And the subsequent either civil suit that occurred, and Ms. Erick says months later, it was a couple of months later. This email was sent in November of 2014, and Dunn filed her civil suit early in 2015. So we're talking about just a couple of months, enough time to prepare the petition in that case. So to state that there's no connection between these things is absurd. Clearly they were intimately connected. This email is proof that they were connected. And where this is a case of where there's fire, there's fire. The court may recall that I filed an emergency motion for discovery in this case, which Ms. Erick, of course, vehemently opposed. And I can understand why, because I assume, and I would imagine, and the court can imagine as well, that there are other emails regarding these Dunn's lawsuits against me. So again, to claim that there's no connection and Michalopoulos is not responsible for Dunn's immediately subsequent lawsuit against me in civil court and the immediately subsequent lawsuit in family court, both requesting gag orders against me, is absurd. Clearly, they're obviously related. There's an email from Ms. Michalopoulos to Dunn and Rochelle telling them to essentially take some kind of legal action, which Dunn and Michalopoulos did. Dunn and Rochelle did, along with Mr. Findlay. And that led directly to the infringement of my constitutional rights. Now, I'm going to skip to my legal arguments to address your question, Your Honor. With regard to constitutional claims, we've covered some of this ground before, but I'll state it again. Private parties are indeed liable for claims under 42 U.S. Code Section 1983 with regard to conspiracy. And the controlling case there is Dennis v. Sparks, 449 U.S. 24, 27 through 28. That's from 1980. Quote, private persons jointly engaged with state officials in the challenged action are acting, quote, under color of law, unquote, for purposes of Section 1983 actions. And that is citing Atticus versus S.H. Kress and Co., 398 U.S. 144 at 398. I'm sorry, at 144, and also 398 U.S. 152, and that's 1970. There's also other case law cited in my response, so I won't belabor that. Certainly defendants, judges Andrea Plumley and Daniel Diaz are state actors, and defendant Michalopoulos, Dunn, and Hockaday all conspired with these state actors in acts violative of my constitutional rights. Again, defendants Michalopoulos, Findlay, and Rochelle are all lawyers, and certainly they are acting under color of law regardless of what they do in any court situation. Thus, all are answerable under 42 U.S. Code Section 1983. Further, this U.S. Supreme Court has ruled that claims under 42 U.S. Code Section 1985 do not require the participation of a state actor. Quote, Section 1985, subsection 3, does not require state action, but reaches private conspiracies, unquote. And that's Griffin v. Breckenridge, 403 U.S. 88, and that's 1971. And as I said before, nor do claims under 42 U.S. Code Section 1985-3 require any racial discrimination element. With regard to the fact that I have not yet, and I plan to, yet explicitly stated a claim under Section 1985, I've noted previously that I filed a notice of special pro se rights in this court on April 16, 2021. And as I indicated in that pleading, quote, the court is under a duty to examine the complaint to determine if allegations provide for relief on any possible theory. And that's Bonner v. Circuit Court of St. Louis, 526 Federal 2nd, 1331 at 1334. That's the 8th Circuit, 1975. And that's, again, there's further case law I've cited in my pleading. So it's quite obvious that the extensive allegations, including my own claims in hearings, explicitly stating a 1985 claim. but the allegations in my original petition alone of conspiracy against my constitutional rights provide for relief under 42 U.S. Code Section 1985(3), and this court is required by law to recognize that potential relief. I'm also, of course, entitled to amend my original petition under Texas Rules of Civil Procedure, Rule 63, which I still plan to do, to explicitly include a claim under 42 U.S. Code Section 1985 and also Section 1986, which covers negligence in the federal statute. Thus, my constitutional claims do indeed have a basis in law and fact, quite obviously, I believe. With regard to fraud, Ms. Erick claims that, again, that her client, Ms. Michaelopoulos, was just not responsible for any of this, anything, the constitutional or financial harm that occurred as a result of Dunn's, Rochelle's, and Findley's lawsuits that they filed in family court. Yet again, we have this email from November of 2014 in which her client instructs those other defendants to file the suit. So again, Ms. Michaelopoulos, either directly or through a defendant Dunn, made a representation to a court of law in Dunn's 2015 custody modification suit that there were grounds for requested modification. And Michaelopoulos personally instructed defendants Dunn and Rochelle to file that suit. I think it's hard, really impossible to interpret that email any other way. And second, that representation was false because there were no grounds for that 2015 modification suit in case number DF13-02616 in the 330th Family Court. And no grounds were ever pleaded in that suit because there were no grounds. Third, when defendants Dunn, Findley, Rochelle, and Michaelopoulos made this representation, they knew it to be false, which is demonstrated by the fact that no grounds for custody modification were ever stated in that case. And defendants Michaelopoulos, Findley, and Rochelle, who were all family law attorneys, knew by their training and profession that grounds are required under state law for filing suit. Fourth, Michaelopoulos, Dunn, Findley, and Rochelle made the representation with the intent that the 330th Family Court act on it, and that court did, issuing a gag order and other illegal restrictions signed by defendant Plumlee in November of 2016. Yes. Fifth, the 330th Family Court and defendant Plumlee, who is an alleged co-conspirator, relied on this representation, issuing an illegal injurious order as a result. That is defendant Plumlee's fraudulent purported order of November 17, 2016. And sixth, this representation has indeed caused me injury, that is subjecting me to a gag order and infringements of my parental rights for 6 years now, as well as financial harm in the form of attorney's fees and court levies in excess of $40,000. And that doesn't even count the harm done to my income from business, which has been severely reduced because of my legal burden. Thus, the elements of fraud are clearly established. With regard to third-party fraud, and again, we've covered this before, but it's not legally necessary that any injurious false representation made by Michaelopoulos or Dunn as agents of Hockaday, this false representation need not be made directly to anyone, or me in particular, in order to establish civil liability. The language in Texas case law is largely generic with regard to the party who hears the misrepresentation. For example, in the case in Ray First Merit Bank in A, and that's in 52 Southwest 3rd, 749 at 758. That's Texas Supreme Court, 2001. And precedent in other states has established that a misrepresentation made to a third party that injures a complainant meets the standard for fraud, and that's in Minnesota.
I'm sorry, Mr. Miller. Can you repeat the case?
Yes, that's a Minnesota case, Vixa versus Flaby, 316 Northwest 2nd, 276 at 284, and that's Minnesota, 1982. There's also another Minnesota case I've cited in my pleading, which I won't repeat. But in addition, the Texas Penal Code section 32.46 and the chapter titled Fraud specifically outlaws, quote, securing execution of document by deception, unquote, and thereby harming a third party. So it would be illogical to claim that a civil fraud claim.
Sorry, Mr. Miller, can you slow down?
Sure, sorry again. Anyway, the Texas Penal Code section 32.46 outlaws, quote, securing execution of document by deception, unquote, and thereby harming a third party. So it would be illogical to claim that civil fraud requires that a harmful misrepresentation be made directly to an injured party. Thus, a false representation made by Michalopoulos or her co-conspirator done to a court or to another person or entity of any kind, which caused harm, would certainly meet the standard for fraud as far as Michalopoulos is concerned. Further, defendant Michalopoulos repeatedly lied to the entire Hockaday board.
Mr. Miller, to be clear, the representation that you're referring to is the email that she forwarded in November of 2014, where she posts the question to them, maybe you should file for a protective order.
No, Your Honor, I'm alleging conspiracy. The false representation was made personally by Dunn, Rochelle, and Findley to the 330th Family Court in the form of their modification petition.
I'm talking about as to this defendant, the movement here.
Yes.
The representation that you're talking about is that email that she forwarded the day after you sent her the email that she forwarded to Ms. Dunn and her counsel, where she said maybe you should seek a protective order.
Yes, as a part of a conspiracy, Your Honor. The misrepresentation specifically that I'm referring to is the groundless family court suit that Dunn filed in response to defendant Michalopoulos' instigation in that email. I'm not saying that email itself was the misrepresentation. The misrepresentation was made probably with the cooperation of Michalopoulos, but individually and personally by Dunn, Rochelle, and Findley in that groundless suit filed in the 330th Family Court in 2015. That's the misrepresentation in which Michalopoulos was clearly a co-conspirator. So I'm really covering the element of conspiracy here and describing the underlying tort of fraud as it relates to defendant Michalopoulos.
Right. And so then the conspiracy, or the evidence, at least in your mind, that demonstrates that you have a basis in law or fact for this theory of liability, is that she forwarded your email to them and said, queried whether they should file or protective order, presumably to stop you from being able to send emails to the Hockaday School.
Yes, or speaking about Dunn's conduct, both of those things. What I'm saying is that the email from defendant Michalopoulos to defendants Dunn and Rochelle indicates that she instigated that the suit subsequently filed by Dunn, in which Dunn made a misrepresentation that there were grounds for custody modification when there were no grounds. And in fact, Dunn, Rochelle, and Findley stated no grounds in their petition.
I understand that you take issue with the veracity of their contentions in that case, but to my understanding, the defendant here, movement here, did not file that case, was not an attorney of record in the case, and was not a party in the filing. Your issue with her is that you feel that she maybe put it on their minds by forwarding the email to them and asking the question that she did. You feel like that constitutes her instigating it because she raised the issue with them. That's correct. I believe the email clearly indicates that she instigated that suit, and therefore she was a co-conspirator. I will, of course, acknowledge that Ms. Michalopoulos did not sign the pleading or file the suit itself, but of course the conspiracy touches anyone involved in the conspiracy, and not just the individual actors, but those who planned the tortious act as well. And what then, is that the same thing that is the basis of the negligence claim? That's different, Your Honor. My negligence claim, which I will get to in a minute, but I actually have an argument regarding negligence, which I will get to if you'll allow me to continue. I'd like to hear the argument regarding negligence. Okay. All right, well, I will cover that now. The elements of negligence, as you're no doubt aware, Your Honor, are the existence of a legal duty, which Ms. Erick stated, owed by one person to another to protect the latter against injury. Second, a breach of that duty. And third, damages proximately resulting from the breach and the
case stating those elements is Firestone Steel Products Company versus Barajas, 972 Southwest 2nd, 608 at 613. That's Texas Supreme Court, 1996. The court decides what duty means in that context, and the standard is, quote, would reasonable people recognize and agree that a duty should exist between the parties? And there are controlling cases there. Joseph H. Seagram and Sons, Inc. versus McGuire, that's 814 Southwest 2nd, 385 at 387, Texas, 1991, and Childs v. Greenville Hospital Authority, 479 Southwest 2nd, 399 through 401. That's Texas Civil Appellate, Texarkana, 1972. In 2015, when defendant Mikolopoulos instructed defendant Dunn to file her groundless custody modification suit, Miriam Mikolopoulos was the board chair of the Hockaday School where my daughter was and is a student. Certainly, a school's board chair who is acting on behalf of the school has a duty to prevent injuries to a parent of a child at the school and to the child herself. Injuries, that might result from, say, being deprived of a parent for 3 years, which has occurred in this case. Any reasonable person would recognize that fact. Mikolopoulos breached that duty by violating my constitutional rights and by conspiring to do so, or at the very least conspiring to do so, and by lying repeatedly in order to conceal her conduct toward me and by extension toward my daughter. The resulting damages, as I've stated, were injuries to my constitutional right to free speech and right to parent, as well as extensive financial harm. I believe that well establishes the claim for negligence. If I may continue.
I'd like to move on to the
Yes.
intentional infliction of emotional distress.
Absolutely, Your Honor. The elements here are that the defendant acted intentionally or recklessly. The conduct was extreme and outrageous. The actions of the defendant caused the plaintiff emotional distress, and the resulting emotional distress was severe. And that's set forth in GTE Southwest, Inc. v. Bruce, 998 Southwest 2nd, 605 at 611, Texas, 1999. First, as I've stated, and as I believe the evidence indicates, Hockaday board chair Miriam Mikolopoulos, the defendant in this case, intentionally instructed fellow Hockaday board executive committee member, defendant Dunn, to file groundless suits with the express intent to violate my First Amendment rights and 14th Amendment parental rights. There's no doubt that this act was intentional because it's evidenced in that email of November 10th, 2014, sent by Mikolopoulos to defendants Dunn and Rochelle. Second, a lawyer's instigation of a fraudulent groundless suit with the purpose of silencing the plaintiff certainly qualifies as extreme and outrageous conduct, especially when that lawyer, defendant Mikolopoulos, was also the board chair of the school where my daughter was enrolled. Attorneys swear a professional oath to the Constitution, and Mikolopoulos clearly violated not only that oath, but also the law. She evidently had no concern for how her actions would affect either me or my daughter, and therefore her conduct was thus both extreme and outrageous. Third, further, defendant Dunn's 2015 modification suit, which was instigated by Mikolopoulos, caused me to spend the next 2 to 3 years of my life defending myself in court, eventually leading to total deprivation of money and my eventual arrest and prosecution for falling behind on child support payments. I've documented my emotional distress extensively in my
Mr.
original.
Miller, Can you slow down?
Yes, sorry.
Thank you.
I have documented my emotional distress extensively in my original petition, as well as in pleadings in various other tangentially related court cases, which I've listed in the original petition in this case on page 13 through 14. Such a campaign of abuse against me could only result in emotional distress. Defendant Mikolopoulos knew that my suffering was a, quote, primary risk, unquote, of her decision to harass me with groundless lawsuits and to conspire in Dunn's campaign of abuse. I suspect that Mikolopoulos' choice of career as a family law attorney allowed her to indulge these abusive impulses while maintaining a facade of respectability, which is all too common in narcissistic psychopaths. Fourth, there is no question, given the extensive description of events and abusive acts contained in my 142-page original petition in this case, and the 8 years of mistreatment that I've endured, that the resulting emotional distress has been severe. Fifth, the harm directly caused by defendant Mikolopoulos has been bad enough, but it's also highly likely that Mikolopoulos was also involved in the procurement of defendant Diaz's fraudulent temporary orders of June 7, 2018, which have kept me from seeing my daughter for 3 years now. It's difficult to imagine any emotional distress more severe than the feeling of having your only child taken from you without grounds. And there is no doubt that Hockaday conspired in that criminal act. And the current regime at Hockaday, of course, was created in large part by Mikolopoulos herself as the board chair and primary fundraiser in the Hockaday Centennial Campaign. As I mentioned in my petition, Mikolopoulos raised $100 million for Hockaday in that campaign. And of course, that there's a lot of money involved here. And I believe that is a big motivator for the conduct of Hockaday and its agents, Mikolopoulos and Dunn, in the events described in this case. No reasonable person would find the conduct of Mikolopoulos, Dunn, and Hockaday to be normal. As I wrote in my petition, the sheer depravity of this conduct is unimaginable. Thus, I believe the elements of intentional infliction of emotional distress have certainly been established and the resulting damages are recoverable. If I may continue with regard to malicious prosecution.
Yes, I'd like to finish up with that. Go ahead.
Yes. It's true that defendant Judge Plumlee did not find in my favor in Dunn's modification suits, but that circumstance is clearly the result of the fact that defendant Plumlee was actively conspiring against my rights with the other defendants named herein, at least defendants Mikolopoulos, Dunn, Rochelle, Fendley, and Diaz. Any reasonable court would have dismissed Dunn's groundless suits and certainly would not have imposed an illegal gag order, which was obviously designed to conceal at least some of these defendants' illegal conduct. I only received adverse rulings from defendants Plumlee and Diaz because I was forced to proceed in a, quote, kangaroo court in clear violation of my 14th Amendment due process rights. For that kangaroo court reference, see Williams v. United States, 341 U.S. 97 at 101, and that's from 1951. I therefore challenge as unconstitutional under the due process clause of the 14th Amendment, the element of malicious prosecution that requires a ruling in the plaintiff's favor. Clearly, as described extensively in this case, fraud rules an adverse ruling void, and I believe that's what's happened.
I'm sorry, Mr. Miller.
Yes,
Can you slow down and repeat the last part?
Yes, clearly as described extensively in this case, fraud renders an adverse ruling void, which I believe happened in defendant Plumlee's court in the 330th. Further, there's no doubt that Mikolopoulos' instigation of Dunn's groundless 2015 modification suit was done with malice. Instructing another person to file a fraudulent suit to obtain a gag order could only have been done with malice. It is impossible to construe such an act in any other light. And Ms. Erick's suggestion to the contrary is absurd. Thus, at the very least, most of the elements of negligence have been met. If I may quickly address the statute of limitations issue, because there's one serious claim that Ms. Erick has made that is incorrect legally. And that is that the Texas Supreme Court recently ruled that conspiracy is a derivative tort. Thus, the statute of limitations for conspiracy is the same as that of the underlying tort. And that case is AgriCorp Inc. versus Electro Circuits International LLC, 580 Southwest 3rd, 136. That's Texas Supreme Court, 2019. Therefore, the statute of limitations for conspiracy to commit fraud is 4 years, not 2, as Ms. Erick claimed. With regard to the timeline of the filing of my suit under the statute of limitations, Ms. Erick's assertion that I filed my suit, quote, over 5 years after first learning of Mikolopoulos' tortious acts is an outright lie. I first learned of Mikolopoulos' email instigating Dunn's groundless 2015 suit on April 6, 2016, which I stated in my original petition at page 45. I did not intercept this communication. It was sent to me on a disk through the United States mail. That was my first notification that this had been going on. I then filed my federal suit against the defendants in this case on March 31st, 2020, within the 4-year statute of limitations for fraud. When my federal civil suit was dismissed on September 17, 2020, I refiled this state civil suit in this court on October 15th, 2020, within 30 days of the dismissal of my federal suit. When a case is filed in federal court, as the United States Supreme Court has ruled, quote, it suspends the statute of limitations for 2 adjacent time periods, while the claim is pending in federal court and for 30 days post dismissal, unquote. And the case there is Artis v. District of Columbia, number 16-460, slip op at 11. Thus, this suit
Does that case speak to the issue Ms. Erick brought up, which is that in this instance, there was no service of the case, and the case was instead the federal case, and instead the matter was dismissed prior to any defendant being served in the case?
Yes, as I've covered in prior pleadings and also in court arguments, hearing arguments. I requested service from federal court. I was proceeding as an indigent party in federal court, as I am in this state court case. I requested that service be made by federal court, and the federal district court of the Northern District of Texas did not serve my complaint in that suit. I could not force them to do it. I could not afford to pay a private process server. To Ms. Erick's assertion that that case wasn't valid because the federal district court did not serve my complaint is certainly a violation of the 14th Amendment in itself. I don't have the power to force a federal court to serve a petition. And again, I've already pled that previously, and it's in I can't remember which pleading that I stated that argument in, but it has certainly been made before this court. The case was filed, the case was docketed in federal court. It's on PACER, and the case or dismissal order. It was dismissal. Sorry, that case was dismissed under Rooker-Feldman, which I believe violated my right to a federal venue for these federal complaints. So I'm covering that now in an appeal in the Fifth Circuit Court of Appeals in New Orleans. But certainly the fact that the case was docketed and the fact that there is a federal court order dismissing the case with a date stamp on it, which I've already covered, indicates that case was valid. It was filed within the statute of limitations. It was dismissed under Rooker-Feldman and refiled within 30 days under the relevant state statute, the state and federal statutes.
Thank you, Mr. Miller. Ms. Erick, I want to give you just a couple minutes before I've got to get to the next matter that needs the court's attention. I want to give you a couple minutes to respond to this legal issue with regard to whether or not the filing of the federal suit without service on the defendants, whether as a matter of law that can constitute tolling. Ms. Erick, you are muted.
Sorry, it's been a while since I've done that, but in regards to just that issue, Your Honor, it makes sense that if a party files a federal lawsuit on certain claims and that lawsuit is proceeding, that the statute of limitations would be told because the defendants in that federal lawsuit would be aware that a lawsuit is proceeding on these claims. But in this circumstance, none of the defendants were made aware that a federal lawsuit was pending. He sued them, apparently. None of them were served. So to toll the statute of limitations when the defendants did not even know these claims were pending against them in a federal court doesn't make sense in this circumstance.
Your Honor, Ms. Erick cites no case law or statute, federal or state, for that assertion. Whether it makes sense to her is irrelevant. I have a United States Supreme Court case that controls this very issue, and it's basically under federal law, under United States Supreme Court precedent. The state court case was filed within the statute of limitations. That's all.
Would you give me the citation again, Mr. Miller, for the case you just referenced?
Yes. And that is in my pleading as well, in my response to the defendant Michalopoulos's motion to dismiss. That case is Artis, A-R-T-I-S, v. District of Columbia, and that's number 16-460, slip op at 11. This was a 2016 case, apparently.
And Your Honor, just to clarify, Mr. Miller doesn't have a case exactly on point. He has a case that says that the tolling period, that the statute of limitations is tolled when there's a federal lawsuit proceeding. He does not have a case that says regardless of whether or not the defendants were served. And that's the issue here.
No, Your Honor, the issue is whether the case was pending in federal court, and this is a controlling and exactly on point case. As I said, from the quote from this ruling, a filing of a case in federal court suspends the statute of limitations for 2 adjacent time periods while the claim is pending in federal court and for 30 days post dismissal. It could not be any more clear. While the case resides in federal court, and I've filed that, basically the claims in the federal suit and in this instant pending state court suit are identical. The defendants are identical and the claims are identical. In fact, the pleadings are, the original petition and the complaint are virtually identical. This case absolutely applies. To claim that it doesn't because somehow the federal district court did not serve my petition is irrelevant.
Okay, well, thank you all for your arguments. The court will review this record as well as that case, and I will get an order out to you all regarding the motion. Thank you all. Everyone is excused.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.